Welcome to U.S. Immigration TV. Now, I know one of the most frustrating and aggravating things that can happen to a person who is applying for immigration benefits is to have their petition or application rejected or denied. Sometimes the case can be denied for seemingly minor mistakes, but the effects could be devastating to the person and their future in the U.S. Well, sometimes if a case is rejected or denied, the person finds themselves out of status and therefore unable to pursue legalization in the U.S. In other situations, a denial might result in the person being placed in deportation or removal proceedings. Well, now, what are some of the things that could get your case denied or rejected? Now, what are some of the things that you can do to avoid that or to protect your case and your future in the U.S.? Now, I've been an attorney for over 40 years, and really tens of thousands of people have consulted with me about their immigration issues and problems. Now, in this video, I will highlight some of the more common reasons or mistakes that people have made that resulted in their cases being rejected or denied. Now, these are real life situations that have happened. People have come to me and the cases had been denied for some of these reasons. And I will also offer tips on how to avoid that happening to you. Now, if this doesn't apply to you, but you know somebody who is applying for immigration benefits, you may want to share this video with them as they may find it informative. And of course, don't forget to subscribe to this channel for more immigration information and updates. Now, let's go through some of the tips to avoid having your case rejected or denied. Number one, make sure the form is properly signed and the correct fee is submitted. The two most important things in order for a person's petition or application to be even accepted is that it must be signed by the proper person and the correct fee paid. Now, many times people forget to sign the form, or it's signed by the wrong person, such as maybe it's signed by the beneficiary rather than the petitioner, or the person does not submit the correct fee. In these cases, it's not even accepted for filing. It's rejected in the mailroom, and it could be sent right back to you. And if you're filing for an extension of status or some other time-sensitive document, you may miss the deadline because of the rejection, and you're going to find yourself out of status. Number two, include all the required evidence. Now, on the USCIS website, they typically list the types of documents and evidence or proof necessary to show eligibility for the benefit you're seeking. Now, for example, if a parent is petitioning a child, it only makes sense that you submit a birth certificate of the child. Also, if, let's say, it's a marital petition, a marriage contract should be submitted. Now, if you leave out or forget to include required evidence, the case could be denied. Now, during Trump's administration, that's exactly what the USCIS did. If you were missing a required document, the case would be denied. Now, under Biden, it's likely that they will go back to the old practice and just issue a request for evidence, giving the person, let's say, 87 days to provide the missing information. But still, you don't want to go through the trauma or take the chance. You have to make sure to include all of the required evidence showing your eligibility for the benefit you are applying for. Number three, make sure to get a filing receipt. Now, once you properly file a petition or application, USCIS is supposed to issue a filing receipt. Now, unfortunately, they're now taking a very long time to issue those receipts, but don't lose track of getting that filing receipt to make sure your case was filed and accepted. Now, if you have not received a filing receipt in many months, there could be a problem, and you may want to see an attorney about that. Number four, send your filings by certified mail, express mail, or Federal Express rather than regular mail, so at least you can keep track of delivery. And of course, keep a copy in a safe place. Now, I've encountered some cases where a person said they filed a petition but never received a filing receipt. If they sent it by regular mail, they're going to have trouble proving that the document was actually filed or received, because you see, when you get a receipt number, that's how USCIS tracks the filings, versus trying to track it in your name. So it's very important that you follow up and make sure at some point you get a filing receipt. As an added item, you may want to pay by check, because even if they don't issue the receipt right away, they may cash the check sooner, and sometimes they write the receipt number on the back of the check. Number 5, monitor the processing of your case. Now, once a petition or application is filed with USCIS, believe me, it's not approved immediately. Depending on the type of the case, it could take 2 or more years before they even look at the case, such as, let's say, a petition by a brother or sister or a married child. On the USCIS website, they post the processing times for particular forms based on the type of form and the location where you filed it. You should check the website for the processing times just to make sure everything is on track. For example, if you filed a particular petition and the processing time on the USCIS website, let's say, indicate it takes 18 months, but it's now 5 years later, something went wrong. In that case, you may want to consult with an attorney who can check and see if everything is okay or what's going on with the case. On the other hand, if the case is still within the posted processing times, there usually would not be a reason to follow up yet. Number 6, check the case status on the USCIS website. If you have a filing receipt number for your filing, you can go to the USCIS website and input that receipt number to check the case status. Now, if it reflects the case was filed and is being processed, usually there's no reason for concern. But I've had some cases where we went and checked the case status based on the receipt number, and it showed that the case was denied and the person was unaware of it, or the case status shows that some notice or decision was mailed but was returned to the USCIS by the post office. Well, in that case, maybe something's wrong and you should consult with an attorney. Number 7, consider a motion to reopen or motion to reconsider if your case is denied in error. Now, in some cases, the USCIS has made a mistake in denying your case. Maybe they claim you never submitted a document in response to an RFE or request for evidence when in fact you did. Maybe there was some misunderstanding or miscommunication concerning the facts of the case, such as, let's say, living arrangements between a husband and wife. If the USCIS has made an error in fact or law, it could be possible to bring a motion to reopen or a motion to reconsider to have them reverse their denial and approve your case. You should consult with an attorney who can evaluate your case and see if that would be appropriate. Number 8, monitor your priority date so your case won't be canceled or abandoned. Now, once a case is approved, it can sometimes take years before a person's priority date is current or visa is available. For example, a petition by a brother or sister or of a married child might take 15 or 20 years. Adult single children of U.S. citizens or immigrants could take 10 years or more. Now, if the beneficiary is outside the U.S. and the priority date is current, the National Visa Center will send notices and give them 1 year to respond. Now, if the person misses that deadline, the National Visa Center could terminate the case and shred the file, and they lose their priority date. Now, I have come across so many cases or consultations where people were asking me about what's happening with their case, and it turned out the priority date was current years ago, and they never applied, and the NVC terminated the case. Therefore, if your priority date is current, but you have not received notices, you should probably consult with an attorney to see what's going on and make sure your case is on track. Number 9, advise the USCIS or NVC of any address changes. Now, as I just said, some cases can take many years before the priority date is finally current or the visa is available. If you move, either the petitioner or the beneficiary, and you do not notify either the USCIS or the NVC of your new address, they will send notices to the last address they have on file for you and give you 1 year to respond. Obviously, you would not have received the notice because it would be returned to the post office and you risk the case being terminated. Now, many people had filed petitions and were waiting patiently for years and finally came to me for a consultation. Now, it turned out that they had moved, but they did not notify the NVC of the new address. They thought that, sending an address change to the post office was sufficient. It is not. You have to notify the NVC and do it in writing. Well, in those cases, the case got terminated because they did not respond within 1 year. Number 10, be fully prepared for your interview or hearing. Now, I've come across many cases that were denied at the interview because, let's say, the person was nervous and scared, or they were confused and they could not answer the question properly, or they maybe misunderstood the questions and the officer became suspicious and then denied the case. This might be especially true in marital cases where you might have a loving couple, but they get confused, and if they're interviewed separately, they may give conflicting answers. Now, while it is certainly possible to try to go back and get the denial reversed, it is so much better if a person is properly prepared and briefed. I know that in my office, we have clients who have upcoming interviews, and we sometimes spend hours before the interview going over the forms and the documents and the type of questions that may be asked and what is the best correct answer, so that when it comes time for the interview, they feel comfortable and confident and are able to answer calmly and correctly. Now, if that's your situation where you have an interview coming up, you may also want to consult with an attorney who can perhaps prepare you for your interview and represent you at that interview. Now, obviously, this is not a complete list of the things you can do to avoid denials. For some of you, some of these tips may seem so obvious and simple, but still, I cannot tell you the number of cases that have come to me for consultation that were denied because of simple mistakes. Now, I hope you found this video informative, or if you think somebody you know could benefit from these tips, please share this video with them. And don't forget to like and, most importantly, subscribe to this channel. I'm Michael Gurfinkel, and this is US Immigration TV.